Right, good morning, everybody. I think there are still a few people in the process of joining this webinar this morning. I can see the numbers slowly creeping up. My name's Lucy Walker, and I'm a specialist in banking and financial services regulation at Guildhall Chambers. And I'm delighted that I'm joined by my colleague, Christopher Hare, who is also a banking specialist at Guildhall. And Chris is also a professor of law at the University of Oxford. We're delighted to speak to you this morning on the topic of crypto assets. Just a couple of housekeeping points before we get going. May I ask everybody, please, just to make sure that their microphones and cameras are muted, obviously not Chris and myself, but everybody else, just to minimize the risk of any interference. The other thing of which I need to make everybody aware is that this webinar is being recorded, and once the recording's done, it will be placed on our website and on the Guildhall Chambers YouTube channel. But what that does mean is that the names and initials and any questions that you as participants may wish to ask, that will obviously be visible firstly to the other participants within this webinar, and also when the webinar goes live on our various social media channels. So obviously I need to make you aware of that as well. We're delighted to take questions this morning. What I would suggest is that we allowed some time at the end of the webinar, which is scheduled to finish at 10 this morning. We've allowed time at the end of the webinar for questions. And I would invite people to submit questions via the chat function. And there's sort of like a little comment bubble thing, which if you press on that on screen will allow you to submit questions. So we'll keep an eye on that, and we'll deal with any questions at the end of the webinar. As I say, we're absolutely delighted to speak to you this morning. In terms of what we'll talk about today, I will do a brief introductory session about what actually is a crypto asset, because obviously these phrases are bandied around and it means different things to different people. So there'll be a brief introductory session just on what is a crypto asset. Then I shall hand over to Chris, who will do the legal analysis of crypto assets. And then Chris will hand back to me, and we shall look at the regulatory analysis of crypto assets in terms of the Financial Conduct Authority's view, current HM Treasury consultation, and then finally we'll wrap up really with an explanation of why does all of this matter? Why does it matter to us as legal professionals and within other professional services industries? Is it reserved to technology geeks to get all enthusiastic about, or will crypto assets have the potential to have a much greater impact on our lives? So there's lots to talk about. So I should kick off really with a consideration of what is a cryptocurrency. Focusing on the word currency, obviously that denotes within society an ability to use that as money. And so if one starts with a consideration of the nature of money, there are three principal functions to money. You can use it as a medium of exchange, so you can pay someone in money and you can transfer value to somebody if you owe them money for something or other. You can use it as a unit of account, in that you can maintain your books of account. You can account to HM Revenue and Customs, should you wish to do so, in respect of your taxes. But those transactions, those accounting transactions, those taxation transactions are all measured and accounted for with reference to that particular unit. You can also use money as a store of value, in that you can use it to save and to invest. So obviously you can store it in a bank account, or you can store it under your bed, or you can buy shares and other investments with it. But those are the principal functions. And it's important to remember in that concept that the control of money or currency is very tightly regulated and very tightly controlled in each country, because to varying degrees, obviously, depending on the economic circumstances. But essentially, money is a legally recognized medium of exchange or store of value or unit of account that's issued by a sovereign government or a central bank, and it's universally accepted. So that if now I hand over a £5 note to Chris, he will accept that £5 note, trusting that I'm not going to give him a dodgy one, obviously, but on that assumption, Chris can happily and freely accept that £5 note, knowing that he can then go and pop it in his bank account or pop down to the shops and exchange that for some newspapers or magazines or whatever. But he doesn't need to look behind the validity of that £5 note as a medium of exchange or a unit of account or a store of value. And obviously in the UK, it's the Bank of England that's the sole issuer of banknotes. Now, all of that background is important in then analysing what it is that actually a cryptocurrency might be. Now, it's a digital representation of value. And the key issue, which is one of the pervasive themes that we'll be running through this morning, is that there is no central issuing authority in relation to a cryptocurrency. That's the present situation. That may change, as I'll go on to explain later. But presently, no central bank, governmental or other monetary issuing authority issues a cryptocurrency. And again, subject to some notable exceptions, a cryptocurrency, the value isn't linked to the value of any sovereign currency or commodity. So a cryptocurrency, generally speaking, isn't backed by the US dollar, it isn't backed by gold or any other commodity reserves. And as I say, there is no single issuer. And it's important to remember that because that's a theme that underpins everything that we're going to speak about this morning. Obviously, there are lots of different types of crypto assets. I mean, Bitcoin, which has been in the news a lot recently, is the most famous example. And again, typifying the sort of sometimes Wild West nature of cryptocurrencies. Dogecoin, which started off as a joke, a social media joke, has now become very prominent as well. But again, another important point to recognize here is that each type of coin uses different technology. Each type of coin has different characteristics and properties. And one of the things that links all of them is that they're very often characterized by extreme price volatility. But as I say, each type of coin is different. You can't assume that they're all the same just because they're labeled a cryptocurrency or a crypto asset. And as I referenced earlier, there's no single issuing authority, but nonetheless, such is the noise that's been created around cryptocurrencies and crypto assets that presently over 50 central banks and governments are looking at issuing their own, the viability of having their own digital currency in circulation. And again, I'll talk about that in more detail later on. Just popped a slide there about Elon Musk, but I'm going to gloss over that and talk about him a bit later, I think. The final point in just this sort of introductory section about what is a cryptocurrency is just to look at the technology that underpins them and what actually facilitates them. And hopefully, again, this will help to set in context the fundamental point that there is no centralized issuer of a cryptocurrency. Because what happens, and I'm going to, this is a very brief summation of the technology, and I'm sure there are many people on this call who know a lot more about this than I do. But by way of brief summary, what happens is that cryptocurrencies are created using essentially computer power and what's known as blockchain technology. Again, that's a generalization because not all cryptocurrencies use blockchain, but a lot of them do. But the important conceptual issue to grasp is that a cryptocurrency, it exists only as an encrypted file on your computer, essentially, so on your hard drive or on your mobile device or in the cloud. There's nothing physical. All that happens when you own a cryptocurrency is that you have ownership of that cryptographic address. And obviously that originates with the person who mined the cryptocurrency unit, and the ownership of the cryptographic address then enables you to access the digital wallet in which the cryptocurrency is stored using your private key. And so obviously that's an adjunct to the ownership of a cryptocurrency, and obviously one needs to possess a digital wallet in which to store it and have the cryptographic address in order then to be able to access that wallet and access your cryptocurrency. And again, anybody who knows about the Quadriga scandal in Canada will know about the importance of accessing a digital wallet. And Chris will talk about digital wallets shortly. All of the transactions in cryptocurrency that are underpinned by blockchain technology, all of those transactions are recorded on the blockchain. And it's the blockchain technology essentially that facilitates crypto assets in terms of those crypto assets that use blockchain technology. A lot of the scam cryptocurrencies didn't use blockchain technology at all. But basically, blockchain is a decentralized ledger, and it records transactions in successive sequential blocks of information, so that when you add a new block of information to the blockchain, the new block checks back to the previous block and checks the data set within the new block against the previous block, which then checks back against the block prior to that, all the way back down the chain to the original block. And so what happens when this technology is utilized is that you have security of transaction, because each block refers back to the data set within the previous block and effectively self-authenticates. And it's very difficult then to change or add or remove information from the blockchain once that's formed. And it's also important to make the point at this stage that blockchain technology is not used solely for crypto assets. It can be used for all sorts of different applications, and indeed is being used for all sorts of different applications because of the security of data that the particular distributed ledger technology presents. So as I say, it's not exclusively used in connection with cryptocurrency and crypto assets. And as I say, it has very wide potential application. So that is a very, very quick navigation through what is a cryptocurrency and the blockchain technology that underpins it. As I say, I would stress it's a very brief summation, but at this juncture, I'm now going to hand over to Chris, who will take you through the legal analysis of cryptocurrencies and current case law.
Thank you. So I think one point that I'd just like to underline to start with is the fact that distributed ledger technology has actually had something of has received something of a bad rap recently because of its association with Bitcoin. But actually, if you take Bitcoin out of the equation, actually distributed ledger technology could be extremely useful in terms of its applications to trade finance, land registry, transactions, and certainly there are lots of different people working on DLT in those different areas. So in terms of my part of the presentation, so I suppose this is an academic banking lawyer's dream, because we can leave the law of checks behind finally and look at something that's really truly cutting edge. And so my interest in this area is really to think about the legal framework that we can wrap around cryptocurrencies and crypto assets, because as ever the technology and commerce has moved ahead, and there's a huge amount of legal lag, which is unsurprising given that we still struggle to work out contracting by email. So it's hardly surprising that we're struggling as lawyers to accommodate cryptocurrencies. In terms of the approaches, I suppose there are two approaches that I've set out on this slide. The first approach is to develop some kind of comprehensive framework that can deal with cryptocurrencies. And essentially the Law Commission is currently consulting on precisely that. So at the moment, Sarah Green is leading a project and is aiming to put together something much more comprehensive than we have at the moment. But that can obviously take a while. So the difficulty we're left with is that we've effectively got to try and fit these things into current legal frameworks. And so that raises a number of questions. So the most obvious question is, well, is this property? Is it property, or is it just a bundle of contractual rights? And if it is property, what kind of property are we talking about? Is it money? Is it goods? Is it services? Is it a beneficial interest under a trust? Is it all of these, depending upon the particular context? So in a way, that's the agenda, I think, at the moment, to try and make our existing frameworks work. So in terms of the first question as to whether a cryptocurrency or crypto asset can be classified as property, the leading approach is still that of Lord Wilberforce in the Ainsworth case. And in that, the court identified that there were 4 criteria that had to be satisfied in order for something to count as property. So the first is that the property has to be definable. And what we mean by that is it must be effectively possible to isolate that asset as an individual asset from other types of asset of the same variety. So it can't just be part of a homogeneous mass. It's got to be, to a degree, separable. It's got to be identifiable by third parties. And what that means is that it's got to be capable of having an identifiable owner. The third criterion is that it's got to be capable in their nature of assumption by third parties. Now this appears to have 2 aspects. One aspect is it's got to be something that has objective value. And given that it has objective value, it's got to be something that the law provides some kind of legal redress when there is unauthorized interference with that particular asset. So there has to be a degree of legal protection that goes with the value in the particular thing that we're looking at. And also, it's got to have a degree of permanence. So if it's something that has only a fleeting presence, then it's not going to count as property. And in many ways, given that we have treated carbon credits as property, given that we've treated milk quotas as property, it's unsurprising that the trend, at least in the cases, is towards categorizing these as property, even though we're not always entirely sure how we're doing that. We know the finishing point, and then the reasoning gets a bit fudged in the middle, but we know where we want to get to. And I think, as I said, I think the finishing point is that we want to treat these things as a form of property. Now we'll see there are some English cases in this area, but actually the most activity has actually happened abroad. And there are 2 cases that I just wanted to highlight for you that I think are really useful in this regard. So the first is a decision called Cryptopia, which is a fairly recent decision of the New Zealand High Court. And what this case concerned was a claim by a liquidator of a crypto trading platform. And the liquidator had made an application to the court for guidance as to how it should categorize cryptocurrencies that the platform still was holding on to, and how it should distribute those assets. And as I've set out on the sheet, Justice Gendel was quite clear that cryptocurrencies are a species of intangible personal property and clearly an identifiable thing of value. And in that regard, the judge specifically referred back to the 4 criteria in the Ainsworth case and said, well, it satisfies the first criterion of being definable because there is a public key that is associated with the crypto asset. The second and third criteria of there being an identifiable owner are satisfied by the fact that there is a private key that is attached to the cryptocurrency, which identifies clearly who has the rights to this asset. And the fact that the cryptocurrency is on an immutable blockchain gives it the degree of permanence that we would look for. So I think Recryptopia is a really helpful case in not only supporting the view that crypto assets are property, but also explaining clearly how the 4 criteria match onto crypto assets. The other case, and I've largely raised this because given it's a Singapore Court of Appeal case, it's probably the highest level common law authority we have on this at the moment. So this is the case of Coin and B2C2. And this was slightly different. This was a claim by a crypto holder against the trading platform. And the crypto holder was complaining about the fact that they had suffered catastrophic losses as a result of algorithmic trading that was occurring on the trading platform. So effectively, they'd set certain parameters, certain trigger points, and once those were hit, then obviously things would be sold or bought. And the complaint essentially was that the trading platform hadn't put in place the kinds of protections or stops that one would expect a trading platform to have in place. And this was really kitchen sink litigation. I mean, virtually every claim under the sun was made. One of the claims, which is the claim that's relevant to our purposes, is that there was a trust relationship between the holder of the digital wallet and the crypto owner. Now, the court ultimately concluded that no trust relationship existed, but I set out on the sheet what the court suggested. They said that there may be much to commend the view that cryptocurrencies should be capable of assimilation into the general concepts of property. There are, however, difficult questions as to the type of property that is involved. So whilst not resounding support, certainly if the Court of Appeal had had to rule on it, then they would have said yes, this is property. In terms of the English cases, we're maybe not quite as rich as we are abroad. I think there are 3 decisions that are probably worth drawing your attention to, and these all move in the same broad direction. So the first one is the Money For case. Now this, and actually the thing that the cases all have in common is that they are dealing with applications for freezing injunctions or some kind of asset preservation order. So that's the context in which the cases have really arisen in England. And in the Money For case, there was an application for a worldwide freezing injunction, and the basis of the complaint was essentially that the crypto owner had placed cryptocurrencies with the trading platform, and these had suddenly disappeared. There was no trace of them anymore. So an application was made for various disclosure orders and for the freezing injunction to make sure that those cryptocurrencies didn't go anywhere. The judge didn't explicitly rule that they were property, but the judge stated this. They said that there had been no suggestion that cryptocurrency cannot be a form of property, or that a party amenable to the court's jurisdiction cannot be enjoined from dealing or disposing of it. So certainly the judge in that case was at least prepared to assume that this was a form of property. The second case, which is really difficult to find, is the case of Robertson and Persons Unknown. And there the judge granted an asset preservation order over crypto assets, but really just didn't consider the property question at all. So the assumption was made that this must be property, but there's really no discussion a bit. The most significant English case to date, though, is the AA case. And here, as with the others, it was an application for a proprietary injunction over Bitcoin. And in a way, the judge started off on a really quite difficult tack, because English law essentially says that property has either got to be a shows in possession or a shows in action. And the judge made sort of the fairly startling conclusion. They said that these are neither shows in possession nor shows in action. And so that's really making life quite difficult for the judge when you make that initial statement. But what the judge went on to say is that actually our understanding of property law has been somewhat flawed, that actually this isn't it, that there are intermediary categories where it's neither a shows in possession or a shows in action. And in deciding what falls within that intermediate category, we can look back at the criteria from the Ainsworth case. And the judge on these particular facts said that he was satisfied that cryptocurrencies fell into this intermediate category. So it's all looking fairly promising in terms of the direction of travel, at least. But I suppose the more difficult question relates to, having decided that this is property, what species of property are we actually dealing with? The most obvious starting point is to say, well, maybe this is money. I mean, certainly people are using it to pay for goods and services. So why can't we just say that this is money, and therefore the framework, the legal framework applicable to money, is just transposed here. The problem with that is that the notion of money has a chameleon-like quality. We don't, apart from a few pieces of legislation that deal with coins and notes as legal tender, we don't have any fixed notion of what money is. And I've set out for you a statement from the relatively old case of Hare and Morgan, where the Lord Chancellor said the word money has not got one natural or usual meaning. It has several meanings, each of which in appropriate circumstances may be regarded as natural, which I suppose translated means you make it up as you go along. So it's quite a difficult question to answer. In terms of trying to answer that, though, certainly if you go to Charles Proctor's writings, he's put forward 3 theories that we could use to decide whether something is money or not. So the first is what we could call the state theory. And this essentially means that something is money if the state says it's money, which is obviously going to be the most obvious meaning of this concept. And I've set out a provision from the US Uniform Commercial Code that lends support to this idea of the state theory. The difficulty for us in terms of the question we're asking today is that the whole point of Bitcoin, the whole point of cryptocurrencies, is to go under the state radar. So although the Bank of England has been playing around with its own type of crypto assets, the Bank of England would never come out openly and say this Bitcoin is money. If anything, they're trying to say precisely the opposite. So if this is the dominant theory, then cryptocurrencies are probably not money. The second option is what we call the societary theory, which effectively says if society believes that something is money, so not the state or the legislature, but society more generally, then we should treat it as money. And I think crypto assets probably have a shot here, because certainly as Bitcoin is growing in popularity, I think there's certainly a relatively strong argument that we could see these as being accepted more widely in society as being a form of payment, as being a form of money. So I think this argument will probably get stronger and stronger. And then the final one is what we call the institutional theory. So this is the idea that something is money if there is an institutional framework around it that allows it to operate as money. Now, again, I think this is problematic for cryptocurrencies because they're essentially based upon a network, and that network is self-executing, it's self-policing. So although you could say there is an institution in a sense because there is a network, there is certainly no overarching oversight or overarching control. So I think it's probably quite hard to bring crypto assets into this third theory. So at least on that approach, I don't think Bitcoin is doing too well. But if we look at the authorities, certainly the case that the courts haven't been quite so shy in terms of treating Bitcoin as money. So one leading example is the ECJ decision in Hedquist. And here what we were dealing with was the provision of services by a Bitcoin exchange that was allowing the exchange of Bitcoin with fiat currencies. And the question was whether that activity was exempt from VAT or not. And there was an exemption that says that if the transaction related to currency, banknotes, and coins used as legal tender, then effectively you didn't have to, the transaction was exempt from that. And so the ECJ held that the Bitcoin transactions actually fell within this particular exemption. If we look to the US has had a raft of cases really where the question has effectively been about whether or not Bitcoin could be treated as money for the purposes of the money laundering legislation or the terrorist financing legislation in that jurisdiction. And I've got three examples. I'll just read the first one to you. So this is the case of SEC and Shavers, where the court says it is clear that Bitcoin can be used as money. It can be used to purchase goods or services and to pay for individual living expenses. The only limitation of Bitcoin is that it is limited to those places that accept it as currency. However, it can also be exchanged for conventional currencies such as the US dollar, euro, yen, and yuan. Therefore, Bitcoin is a currency or form of money. And I've set out on the next slide two other US cases where the judges in the same context make very much the same comments. So the Ulbricht case, which arose out of the Silk Road, website, where effectively Bitcoin was being used to pay for arms and all sorts of underworld activity. So Ulbricht sort of related to that, and we see again two statements from the US courts in a similar vein. So it could be money. The problem is, if it's money, then it probably can't be goods. Because if we look at the definition of goods that we find in the Sale of Goods Act, then it says that it's got to be all personal chattels other than things in action and money. So this suggests that we can't have it both ways. That either it's money or it's a good and falls within that particular piece of legislation. But I would put a question mark over that. And this is in relation to the very old case of Moss and Hancock, where you effectively had somebody who was selling a £5 gold coin, which was actually legal tender, so you could use it as money, but was being sold as a curiosity or as an antique. And so the question there was whether or not that coin was money or goods. And the court was prepared to say that although it was money in one sense, it was also goods for the purposes of the Sale of Goods Act. So certainly Moss and Hancock might be used to leverage an argument that you don't have to make a binary choice between money or goods, that actually you could hedge your bets and have it both ways depending on the circumstances. And then the final suggestion is that in the ECJ case I referred to a moment ago, there is a suggestion that actually cryptocurrencies may involve the provision of a service, although again I suspect that was fairly context specific. So what we are left with, just summarizing those cases, is whilst cryptocurrencies seem to be property, how we think of them as property depends very much on the context in which the issue arises. And it strikes me that the courts are pretty much just classifying it how they wish in a very instrumental way. That they're deciding where they want to get to, and then they are classifying it accordingly. And therefore, we see Bitcoin is money and goods and services and a trust and everything else under the sun. So, two very brief final points. The first final point is that there are really serious private law implications that flow from how we do this. So if we call something property or not property, that may affect the question as to whether or not we can trace into and through cryptocurrencies, whether we can assert some kind of proprietary claim to cryptocurrencies. It could affect choice of law questions. So if cryptocurrencies are property, then we have to work out the lex situs of that property. And I have no idea how you go about doing that. I mean, it's a network. So where do we locate cryptocurrencies? Is it the crypto holder's domicile? Is it the location of the digital wallet? Is it the exchange upon which they're traded? So there are some really difficult conflict of laws questions that have to be resolved as a result of this. It will alter how we vindicate rights. If it's money hadn't received. If it's goods, it's conversion. If it's an interest under a trust, it's no receipt. If it's information, then it's breach of confidence. So how we classify it, again, will determine our vindicatory rights. And it may also determine the implied terms that apply if I transfer the cryptocurrency. So that's just a taste. I mean, there are many, many more, but that's just a taste of some of the horrors that lie out there, according to how we think of this as an asset. And then one very brief final point on digital wallets. So increasingly, we are seeing that the cryptocurrencies are being held not on hardware wallets, which is effectively a laptop or a mobile phone device. They're being held in hosted wallets. So there are companies that are providing these digital wallets for crypto owners. And obviously that therefore gives rise to the question, well, what is the nature of the relationship that exists between the digital wallet provider and the crypto owner? And there are two aspects to that I've just set out on the last of my slides. The first is a proprietary aspect. And this proprietary aspect was considered in both Recryptopia and the coin case. And the proprietary aspect is this: should we say that relationship between the digital wallet provider and the crypto owner is a trust or not? Well, here the foreign courts have differed. In Recryptopia, the New Zealand High Court found that a trust existed, but the Singapore Court of Appeal refused to do so in the other case. So that's going to be an interesting development, and will determine obviously the degree of investor protection that people are going to have as a result of owning cryptocurrencies. And then, so that's the proprietary issue of that relationship. The contractual issue is essentially, well, if you look at the current contracts that are being used, they're extraordinarily embryonic. I mean, there are some terms about how you use the wallet and when it can be taken off you, but that's pretty much it. They're very, very sparse. Now, obviously, over time, that's going to change as the market develops. But I predict that at least in the interim, the relationship, very much like the relationship between a bank and a customer, is going to be governed by implied terms. And I've set out on the sheet the kinds of implied terms that we're going to find. So the standard ones, that will be a duty to obey mandate. There'll be a duty to provide the services with reasonable skill and care. There will clearly be a duty of confidentiality, in my view, given the confidential nature of the private key. And there may also, unlike a bank, be fiduciary duties between the digital wallet provider and the crypto owner. But that's going to depend upon the answer to the first question on this particular slide: is it a trust or not? So that's just a quick trot through some of the, I think, sort of the private law aspects. And I think Lucy's now going to talk about the regulatory aspects of these things, whatever we call them.
Thanks very much, Chris. Right, yes, as Chris has said, in the final part of this session, we're going to have a look at the current regulatory landscape here in the UK as regards crypto assets. Just to pick up on the points that Chris was making just now about the digital wallet providers and the relationship with the holders of cryptocurrencies who then store crypto assets, cryptocurrencies in those digital wallets, I think it's a very salient point to bear that in mind as we walk through the regulatory landscape, because as Chris mentioned, and as we will see when we look at the regulatory status of crypto assets, so much falls outside the regulatory perimeter. And therefore, that means that there's also then a lack of control, a lack of leverage over those digital wallet providers in terms of the protections and security that can be afforded to the holders of digital currency. And as I say, the protections, whether they are statutory or contractual, the protections that are available to them. So the regulatory treatment of crypto assets. The present situation is that, generally speaking, crypto assets fall outside the regulatory perimeter that derives from the Financial Services and Markets Act. And what that means is that the crypto assets comprised in various coins and tokens themselves, they fall outside the definition of specified investments, which are listed at Part 3 of the Financial Services and Markets Act Regulated Activities Order. And the knock-on effect of that is that activity connected with crypto assets, so for example, arranging transactions in crypto assets, offering custodian or wallet services, trading in crypto assets, or operating a crypto asset exchange or a trading platform. Generally speaking, none of those activities are specified activity for the purposes of the Regulated Activities Order. So that's the starting point. But as I say, as with everything to do with crypto assets, that's the general rule. And it's important then to sort of drill down into the detail, because there are some exceptions to this. The first exception is that there may, under certain circumstances, be crypto assets or cryptocurrencies that qualify as electronic money. Now, again, the starting point is, and it's sensible to ask, that if cryptocurrency is a digital representation of value, then why isn't it electronic money for regulatory purposes? Well, to answer that question, it's necessary to look at the definition of electronic money at Regulation 2 of the Electronic Money Regulations 2011. And what that says is that electronic money is stored monetary value, electronically stored monetary value, representing a claim on the issuer and that's issued on receipt of funds. Now, generally speaking, cryptocurrency falls outside the definition of electronic money, basically because it's decentralized, it's permissionless, and as we've seen throughout this morning's webinar, there is no single issuer against whom a claim for that electronic money can be made upon receipt of funds. And also, because of the myriad different variations of cryptocurrency, crypto assets, and the properties and rights that are associated with individual types of cryptocurrency and crypto asset, it's not necessarily the case that a cryptocurrency will actually be an electronically stored monetary value. It may have some different value. So some cryptocurrencies may, on analysis, fall within the definition of electronic money, but the general rule is that they fall outside because they're decentralized and permissionless. That's the main driver of why they fall outside that particular definition. So the FCA has been doing work, ongoing work on crypto assets, and trying to analyze the effect on consumers and whether there's a perceived consumer harm, and trying to classify the various different types of crypto asset in order then to assess whether these concepts, these things, whatever you call them, because we've already seen the difficulty of classification, whether they then should be brought within the regulatory perimeter. Now, the FCA, in its policy statement of July 2019, identified 3 different types of crypto asset. And those crypto assets were exchange tokens. And again, characteristics of an exchange token is that they're not issued or backed by any central authority or monetary authority. But the point of an exchange token generally is that it can be used to pay for goods and services. It's designed as a means of exchange. And as I say, they generally fall outside the perimeter, so they're not subject to regulatory control. So exchange tokens, that's category 1. Category 2 that was identified by the FCA in their policy statement was utility tokens. And again, they're not issued or backed by any single issuer. But what they do is they have associated rights that are attached to the utility token that grant to the holders of that utility token, for example, access to some particular type of product or service, or access to some particular event or treat. They're not specified investments in any way, shape, or form, but they may, under certain circumstances, qualify as electronic money. However, it's important to remember with utility tokens that there must be some sort of particular feature that grants to the holder a particular right. And I think the FCA used, by way of example, a particular issuance of utility tokens that had granted to the holders the right to test drive a particular sports car well in advance of the general public. The final category that was identified by the FCA were security tokens. And a security token is essentially a token with very specific characteristics that mean that the characteristics or rights that are associated with that security token are very similar to characteristics and rights of specified investments, both under the Markets in Financial Instruments Directive and also as set out within the Regulated Activities Order. So that in practical terms, the rights that are associated with the security token are very similar to rights that might be associated with stocks, shares, debentures, warrants, but they have the characteristics of specified investments. So bearing in mind those 3 different types of characterization of crypto assets identified by the FCA, the 2 categories then that are likely to fall within the regulatory perimeter would be those particular crypto assets that meet the definition of electronic money, which I think are probably going to be few and far between, and security tokens, which provide those rights similar to specified investments and so will fall within the regulatory perimeter. And the other category or rather the other feature to note at this point is that there are also derivative products such as futures, options and contracts for differences that have crypto assets as the reference asset, so that you can effectively bet on the future price of Bitcoin or purchase an option to purchase Bitcoin at a future date at a particular price. Now, it's important to remember at this point that the derivative contract itself, so the future, the option, the contract for difference, actually purchased by a punter, that contract is a regulated product. It is a specified investment for the purposes of the Regulated Activities Order, even if the underlying reference asset comprised in the cryptocurrency or the crypto asset is not itself a regulated product. So when considering these particular issues, it's always very important to make that distinction between the contract that's actually being purchased, which, if it's a derivative contract, then of itself is regulated, even if the underlying asset is not itself regulated. So, where did the FCA get to after making all these analyses and classifications? Well, it perceived that the scope for consumer harm, and as an aside, that is the essential function of the FCA, it's to prevent consumer harm. They perceived that the scope for consumer harm in relation to crypto assets, cryptocurrencies generally, had not yet reached a critical mass that intervention was required, but they were very concerned about the sale to retail investors of derivative products that reference crypto assets because of lack of transparency and price volatility. So those products were the sale of derivative products referencing crypto assets were banned with effect from January this year. Otherwise, the view very much was that utility tokens and exchange tokens that fall outside the regulatory perimeter, there was no need to take action yet, but they're going to keep an eye on things. And as we've seen, tokens such as security tokens and tokens that meet the definition of electronic money will in any event fall within the regulatory perimeter. I would stress at this point that each token, each crypto asset has its own rights, its own characteristics, and there will be many, many tokens that won't fall neatly within the classifications identified by the FCA. It is of vital importance in each instance to check and to make one's own assessment about whether a particular crypto asset or cryptocurrency, or indeed token, falls within or without the regulatory perimeter. Because as I say, it's going to be the case probably 9 times out of 10 that the tokens won't necessarily fall within those neat classifications identified by the FCA. Work has also been conducted by HM Treasury, and what HM Treasury are currently looking at is whether to bring what they have identified as stable coins within the regulatory perimeter. Now, a stable coin is a type of crypto asset that can be used as a means of exchange. So within the FCA classifications, it would be an exchange token in that one can use it to buy goods and services and pay for stuff. But the distinguishing feature of a stable coin is that its value will be linked to a particular commodity or a particular fiat currency, i.e. a state-backed currency, so that it will hopefully, theoretically, experience less price volatility because the value is pegged to a stable currency or a stable commodity. And I think HM Treasury, as I say, is currently consulting on whether to bring stable coins within the regulatory perimeter, because it sees value in the widespread usage of stable coins as a means of payment, as a means of exchange. I mentioned earlier that a lot of governments and monetary authorities are looking at issuing their own digital currencies. And so in tandem with consideration, the current HM Treasury consideration of whether to bring stable coins within the regulatory perimeter, it does sort of beg the question, well, why is there this interest? What is the point of bringing stable coins or within the regulatory perimeter, or having governments issue their own digital currencies? And it all boils down to the issue of control. Because as Chris mentioned in his section of this webinar, the potential is that if digital currencies, tokens, crypto assets are used in a widespread manner as a means of exchange or a store of value, the potential is that you have a parallel economy that's outside fiscal and monetary control, that offers no protection to consumers, and that actually can theoretically and potentially affect economic stability. As I say, you have this parallel economy where people are using a means of exchange or a store of value or a unit of account that is actually outside regulation and outside recognized legal tender, recognized monetary policy. So that's the point. It's all about exerting control and also offering protection to consumers. For example, if their digital wallet holder suddenly disappears with all their Bitcoin, as happened in the Canadian quadriga case. Anyway, we are fast approaching the end of this webinar. So just as a final point to make, crypto assets are within the scope of the Anti-Money Laundering Directive. So custodian wallet providers and exchange providers must now comply with anti-money laundering and anti-terrorist financing legislation. HMRC obviously says that trading in crypto assets gives rise to liabilities in capital gains tax. And then on the final couple of slides, I've just listed some key points as to why lawyers increasingly will need to understand the nature of crypto assets and blockchain technology, and why these things are important in terms of the type of advice that we as lawyers may be required to give to our clients. And obviously, that extends beyond the legal and regulatory analysis of crypto assets and cryptocurrencies, but it may extend to issues like, can I accept payment for my legal services in Bitcoin or another crypto asset? How can I do that? Is that possible? And also then advice in connection with insolvency or bankruptcy proceedings, where the insolvent or bankrupt estate has crypto assets within it, and also family law and private law matters in the context of tax planning or family proceedings. And also contentious advice as well. You know, what do I do if my Bitcoin's been stolen? So all these questions are up in the air, but it's increasingly important that we need to understand them. So that brings the formal part of this morning's webinar to a close. I'm not sure if we've had any questions yet, but I would invite anybody who's got any questions to just pop them in the chat function. I see that we've had a question relating to digital wallet providers who characterize themselves as service providers, and what are our thoughts on that in terms of whether it's a service or, as Chris alluded to, whether they are trustees. Chris, if I might hand that question back to you, as it directly referenced what you were talking about.
I suppose my initial thoughts are that's so much clever marketing, in the sense that as I indicated in comparing the New Zealand case and the Singaporean case, I think the battleground, at least until the regulatory framework is properly in place, I think the battleground is going to be between whether it's a trust or not a trust. And so I suspect by classifying themselves as service providers, the more you repeat that, the more you're saying we are not trustees, we are not fiduciaries. So I suspect that's my sense, at least, that's so much marketing to try and get away from the risk that they may down the line be categorized as a fiduciary.
Right, we've had another question from Will, whether we have any thoughts about the regulatory treatment of non-fungible tokens, and whether they could be seen as derivatives, as they are a token whose value is linked to an underlying asset. I mean, there are conceptual similarities. Non-fungible tokens, that's a really interesting question, actually, because, I mean, again, there was a lot of publicity very recently with the sale of an artwork that essentially didn't exist in the real world. It existed digitally, and essentially the key, the token that represented this digital artwork, then sold at a massive price at auction. So there are similarities, I think, with an option or a future, because particularly if you're buying something like an artwork, you are essentially taking a punt on the future value of that. I mean, right now, the regulatory landscape is that a non-fungible token, particularly represented in the piece of art, is well outside the regulatory perimeter. And I think it's about making that distinction between, what you're buying. Are you buying a contract that is essentially a bet on the future underlying asset value, or are you actually buying the underlying asset? And I think that, at the moment, that probably holds the key to the current treatment of non-fungible tokens. It's actually going through that process and working out what it is that one is buying. As I say, is it actually a derivative contract? Are you buying art futures, or are you buying art? Now, obviously, NFTs aren't limited purely to works of art. I'm just sort of latched onto that because it's currently in the news. But I think to try and answer that currently, that is the essential question to ask. Chris, I don't know whether you've got any further thoughts on NFT. We have one final question, that the FCA have talked a lot about regulation, but are they actually going to do anything? How much appetite do they actually have to do anything? My perception is that they don't want to be caught on the hop here, and it's a matter of monitoring presently essentially the wider take-up of crypto assets in whatever form, whether it's a means of exchange or a store of value. And if there is a perception that there is widespread consumer take-up such that there is potential for consumer harm, then that's the point at which the FCA will intervene. So we've already seen that they've banned the sale of derivative contracts referencing crypto assets to retail consumers. And I'm sure that we'll see further things come from the FCA where they perceive that there are particular pockets of consumer harm. I think actually the real activity will be at HM Treasury and at the macroeconomic level in order to create perhaps a Dogecoin, a digital currency issued by the Bank of England. Again, it's about economic control, and also, think in practical terms, how much money and time and space and storage, if you have a medium of exchange that replaces physical cash and bypasses cumbersome existing payment infrastructure, then the benefits could be myriad. So as I say, my hunch at the moment is that it will be HM Treasury and Bank of England that will drive further regulation, further intervention on these topics. Again, Chris, I don't know if you've anything to add to that.
No, I agree with your point that effectively whether the FCA takes serious action on it is going to depend upon the amount of take up, and as you say, whether there are clear indications of that investors are being harmed by this. So I suspect that's the tipping point we will maybe eventually reach.
Okay, I think that's it on the questions. So unless anybody else has any other questions, I shall wrap up. Chris and I thank everybody very much indeed for joining us this morning. Please do not hesitate, our contact details are on the final slide, so please do not hesitate to drop either of us a line should you have any further questions. We're always delighted to chat on this topic. So thank you very much for everybody for attending, and hopefully we look forward to seeing you at further Guildhall Chambers events in the future. Thanks very much, everybody.
Thank you.